Hi, I'm Lance. Welcome to Fill the Boot, a series of tips and advice for early stage founders and interviews with entrepreneurial experts. Now, I talk to a lot of founders who are confused about patents and other intellectual property because it comes up a lot when they're talking to angel investors or venture capitalists who want to know how well defended is their business. Can they keep competitors at bay? Do they have an intellectual property portfolio? And so I wanted to do an episode on that. But despite the fact that I have a few patents, I am not a patent expert. So I went and got my friend Adam Philipp, who definitely is. He's been practicing patent law for over 25 years. He founded the patent law firm AEON Law, and he specializes in high-tech and software startups all the way through large companies. So he's the man to bring in to tell you about what you need to know as an early stage founder with respect to intellectual property. Adam, welcome to Fill the Boot.
Thank you. I'm glad to be here.
So why don't you just introduce yourself really briefly before we get into the meat of this episode?
So I'm a patent attorney. I run the law firm called AEON Law out of Seattle. My background is computer science, but our firm works with all kinds of technologies, and from individuals and startups to mid-size to Fortune 50 companies.
Now, we've talked a lot about intellectual property over the years. I mean, we've known each other for 27 years or something like that. But when I talk to founders, I find a lot of them are confused about intellectual property. They get asked about it a lot. Angel investors are going to ask what kind of IP protection they have. Maybe you could just do a quick overview of what are the different kinds of intellectual property.
Well, there are really only four kinds of intellectual property, but surprisingly, with only four kinds of intellectual property, people still get confused as to what covers what. So the one I actually like to start off with when I'm talking with founders of startup companies is actually their brand. And that is covered by trademarks. Because I see more collisions, especially in this day and age of domain names and websites that have particular names. I see more collisions on intellectual property with brands than almost any other kind of intellectual property at the early stages for founders. And protecting your brand with a trademark registration is one of the cheapest, easiest insurance policies to not have trouble later on. So trademarks cover your name, your logo, your slogan. The one that everyone likes to talk about, the big kahuna of the types of intellectual property protection, is patents. Patents protect inventions. Now, inventions aren't ideas. They're the combination of an idea or concept plus the understanding of how to actually enable that, how to get it to work. We call it reduction to practice. And so if you combine the idea, which is, wouldn't it be great if we had a solution to this problem, plus everything you need to know to get it to work, we can craft that into a patent. So patents cover technologies, processes, products. Now, contrast that with copyright. Copyright protects content. So if somebody has words, images, video, art, things that aren't functional in and of themselves, but it's content that they have created, that's protected by copyright. And the fourth one often isn't talked about because you don't need to do anything to get the protection, and that is trade secrets. A trade secret is just a secret that you keep that's valuable for your business. And the most important thing about trade secrets is that they are secret. As soon as it's not secret, the intellectual property evaporates. And so the work that you would do with an intellectual property attorney to protect your trade secrets is more about protecting your perimeter rather than protecting the IP itself. You don't want anybody to get in and find out that secret. And there are ways you can set up legal agreements for your employees, partners, licensees to do so.
So that's where things like non-disclosure agreements start to come in.
Exactly. Or when there's a confidentiality clause in an employment agreement saying, I am not going to talk about what my employer tells me to work on.
So, in addition to the trademark protection that you said, that's kind of the first thing that people run into. What other kinds of IP protections should early stage, let's assume technical founders, be thinking about or worrying about early on in the stages of their company?
So I'm I'm very fond of using tools to protect uh, that early secret sauce that founders have. They they've hit on something that's worth starting a company. And often there is some invention there that could be preserved. Now, there are aggressive ways of going after patent protection and building up a robust patent portfolio, but there are also some very cash conservative ways that you can at least lock in some early protection and then test the marketplace to see if there is actually something worth going forward with and spending more substantial founders' cash on. But the tool that I usually recommend for startups is a provisional patent application. And a provisional patent application, it's just it's a tool that locks in an early filing date. And it preserves not only the US protection, but also your international protection. Because there's a global treaty called the Paris Convention that says that if you file a patent in one country, they will give you a year grace period in which to seek patent protection anywhere else in the world where a country has signed that treaty. And a provisional patent application for a relatively modest amount, usually less than a quarter of what it would cost to file a full patent application, can preserve that patent protection both in the US and globally early on for startups. And then they can look at whether it's going to be a market that's worth protecting. Because the other thing that many founders don't realize is that patents are not permissive rights. They don't give you the right to be in the marketplace. You don't need a patent to get permission to be in the marketplace. A patent is a tool that you can use to exclude other people from the marketplace. It's a negative right, the right to exclude people. And so when you get a patent that's actually issued, you can then turn around and ask people to stop infringing on your patent at the risk of paying damages or a court ordering them to stop doing that type of activity. And that tool is going to be a more sophisticated tool than what a startup founder needs right away. But having that protection will often answer the question that investors are asking, what's the barrier of entry of somebody coming into the marketplace after you? And it's an easy answer to say, well, I have a high quality patent or patent portfolio that's going to make it difficult for people to replicate these inventions.
So that kind of begs the question, what makes for a high quality patent or patent portfolio? How do you know whether or not this is of quality?
It's a good question. So it's a bit like hiring an architect. So if you have a valuable plot of land that you want to maximize the value of what you're going to build on it, you could either build something yourself, a nice DIY project, or you can hire an architect to build the appropriate building there. Now, people are more used to judging structures than they are used to judging patents. But there are people who are used to and trained evaluators of patents, and they're usually patent attorneys or patent agents or other attorneys who have experience reading patents, those that are in the patent litigation business. And the place where all of those experienced patent evaluators start which is the last place that most non-patent attorneys start with when they're looking at a patent, is the patent claims. Because a patent is made up of three main sections. There's drawings, description, and claims. And the claims are the actual intellectual property boundary lines that are drawn. And drafting patent claims is what patent attorneys do that's equivalent to the architect building a beautiful building. Because in a patent claim, less is more. Because if you think back to patents being a negative right, the way you exclude people from the marketplace is by matching up each element that's in the claims against a competitor's product. And if you can find each element in the claims in a competitor's infringing product, it's infringing. If that product is missing one of the elements, it's not infringing. So a poorly written claim would have a bunch of unnecessary elements that a competitor could leave out of their product, and then they wouldn't be infringing. And so if you have too much clutter in your claims, you end up with less protection. So it's very much a situation where less is more. But if you get too little in the claims, you run the risk of being overbroad and including something that existed before the patent was filed, which you're not allowed to do. You can't patent something that already existed. And if a claim covers something that already existed, that claim is held to be invalid in court. And so the way we build up a set of good, high-quality patent claims for a client is we treat it like defensive perimeters. So if you think of old castle theories, when, in medieval warfare, there would be an outer open field that the archers could protect, and then there would be an inner stockade, and then there would be a moat, and then there would be outer walls, and then there would be inner walls, and then there would be an inner tower. And you start with that broad open territory which you want to protect. But as you get closer to the center, the core of what the invention is that the startup wants to really protect, you get narrower and narrower, but stronger and stronger defenses.
Yeah, and this is really a dark art because I've got a number of patents. I've worked on a number of these things, and it's very funny. You sit down with a patent attorney and you describe the invention, and then you get back this set of claims, and it can often take a long time to actually recognize your invention inside the claim because they've been written in such a carefully crafted way to kind of remove all the specifics about what you're doing and try to generalize it as much as possible.
I once had a very fruitful half-hour discussion with one of my patent attorneys on whether a comma should or should not exist in a certain place in the claims. And we were talking about, okay, where does that shift the perimeter here if we're using this, and how will it be interpreted in the court, and how will it be interpreted by a jury? And it's one of those lovely, I like to call patents, and particularly patent claims, gems. When you're negotiating with other people in the marketplace, having a patent can really give you an asset that allows for lots of extra negotiations that would be different than the kind of negotiations you could have if you just had coins, money. But when you're looking at gems, you need to look at them from all sides. Like, how would they look if you're licensing to somebody? How would they look if you're litigating with somebody? How would it look to a general purchaser? How would it look to a strategic purchaser? And so you need to look at the gem from all sides to make sure it shines from every direction. Or if you only care about a certain direction, then maximize its beauty from that perspective.
Now, for founders who don't yet have their patent protections in place, even provisionals, they're often very concerned about giving away their secrets, especially when they're talking to investors. Angel investors are famously unwilling to sign non-disclosure agreements because we just talk to far too many people. And that can make the founders pretty nervous about sharing and knowing what to share. So what's your guidance in terms of what sort of things is it safe to be sharing with potential investors, and what things do they actually need to worry about protecting and hiding?
best practice is filing a patent application first before you're broadly talking to most people. That said, the US, there is a grace period from when you first publicly disclose something. You have a 1-year grace period before you need to file for patent protection if you've publicly disclosed what your invention is. The problem with that is that's US specific, and most other countries around the world, the instant you publicly disclose your patent application or your invention, you destroy those rights. And there is no safe way to disclose how your invention works unless you have filed for patent protection first, if you want to preserve your international rights and your US rights. That said, when I was talking about what an invention is, it's how you solve a problem. If you go back to a higher level, a meta level, and just say, I have a solution to the following problem, but don't go into any of the details about how you solve it. Now, that may not be very satisfying to talk with an investor who wants to know a lot more before they're going to invest. But for the initial stages, to pique somebody's interest, if you just identify what the problem is, because that's public, and then you identify what your solution is, but not how it works, that may be safe, unless it's such a simple solution that somebody could figure out the how from you telling them the what. And that's a judgment call. But if you're worried about those kinds of things, it's often good to get something on file. And so when I actually talk with some of my very, very early stage clients that are working in business plan competitions or something like that, where they have a controlled disclosure to investors, I'll say, let's take your pitch and everything that you're going to be disclosing in this presentation that you're going to do, and let's just file that as a provisional patent application. Now, that has one of two effects. Either it's not sufficiently detailed to give you patent protection, in which case what they disclose wouldn't have been sufficient to destroy the patent rights in the first place, or it would have been enough information that it would have destroyed the patent rights, and then therefore it would be enough to provide some patent protection. But if they do well in the business plan competition, okay, let's take some of those proceeds and at least get a provisional filed where we've thoughtfully crafted out the rest of it.
There's no downside. Either it provides some protection or it does no
Exactly.
harm.
So that's a routine step that we'll take. Now, if you're going to talk with some angel investors or VCs who are going to be peppering you with all kinds of questions that you don't have control over, then I'm much more comfortable if my clients have filed some type of thoughtful patent application first. And there are some ways to go about that are cash conservative. And there are even some, I hesitate to even mention this, but occasionally there have been some patent attorneys that have been willing to work on an equity basis early on, if the idea is good enough. But treat them like any other angel investor, with the one caveat that attorneys come with their built-in non-disclosure agreement, so you can talk to them about anything. If it's about having an engagement with them, then it's covered by attorney-client privilege.
So ballpark, what should a founder be expecting to pay for a full patent application?
Ballpark, with our firm, it's going to be between $30,000 to $35,000 over the life of the patent application. We offer flat fees for our projects, and so some of them are defined as a complete project at $30,000. There are other ones where we pay over stages, and they're unpredictable, but averages out around $35,000. They're flat fees along the way.
So, are there any big landmines, key do's or don'ts that you frequently are warning your clients about?
Well, I talked before about that 1 year statutory bar in the US. Oftentimes, founders put off the hard decision about how to build their IP portfolio for more than 1 year. And then we have to have a really hard conversation about what is still protectable. Because if you go beyond that 1 year, there's no point wasting the money on the patent application on that original material because the first time you use that tool, it's going to break. Because if the opposing competitor hops on Google and can find out that your product was available more than 1 year before your patent application was filed, they're just going to have their lawyer send a letter back saying, we're going to ignore you because your tool has no teeth.
So, if the methodology is hidden inside the code or is on the server side of some SaaS solution, has it been disclosed when you release that
So
SaaS
that's
product?
it's a really good question. And that question went all the way up to the Supreme Court. And the answer is yes, it has been. It's not disclosed, but it's considered on sale, even if all that code is secret. So it's both a public disclosure bar and there's an on sale bar. So if you've been commercializing it for more than a year. Now, there are some, I should give you my attorney answer, which is it depends. Uh,
We'll take that as read with everything.
but if you have a secret solution and it's the only solution that can provide this result, um, and you've been using it for more than 1 year and you haven't filed for patent protection, that's probably going to subject you to an on sale bar. But if there were multiple different techniques that could have been used to arrive at that solution, one of which was your secret solution, and you were utilizing all of them, then it's still yet to be decided by courts if that is going to actually trigger the on sale bar or a public disclosure bar. And there's been one case that has come down at least that said that that wasn't enough to trigger the bar. So, but you're asking some of the most cutting edge questions there on what constitutes that release and the triggering event. Um,
I guess this is often intellectually interesting, but out of an abundance of caution, you probably don't want to skate right to the edge of these
uh,
things. It's good to leave a wide
it's
margin.
very good to leave a wide margin, and it's great to take a staged approach. So often when I'm talking with founders that are going through the investment cycle where they have founders cash, they're expecting to talk to angels, and then they're looking at more institutional investors after that. Take that founders cash or seed investment early on and get provisional patents filed on the things that are the reason why you started the company. There are those core concepts and inventions that were the aha moments or the motivation that founders had to actually get the company going. And then when angel investors come and they say, hey, why do you only have provisionals? The founder response is, that's why I'm coming to you. I did my due diligence and duty of preserving the jewels that I had crafted. Now I'm asking for a little bit more cash so I can turn those into non-provisionals that are going to be assets for the company and that are going to enhance the value of your investment. And so,
Now, how do you help the founders think through that of which of the provisionals perhaps that they filed are the ones that are worth spending that money on? How do you determine other than just hiring an attorney to go look at them?
so we we usually have a process. Um, it's a threefold process where you look at it from three different perspectives. So You look at it from a legal perspective, or first I look at it from a legal perspective. Is this the kind of thing that can be protected by a patent or other form of intellectual property? And that's usually not much of a gray area. It's yes or no. Or there could be a little bit of gray. It's probably yes. But then there's the business perspective. Is this invention that is closely tied with our business goals? Is this going to be the kind of thing that we can use in our business to further the purpose of this business? And that requires somebody from the business side of the startup to know what they're trying to do. Important part of the startup business. But then also from the technology side, because oftentimes with technologies, there are alternative technologies that are available that could accomplish the same thing. They may be a little bit more expensive, but the incremental cost of using a more expensive alternative might be enough that a competitor would just use that alternative and avoid the patent altogether. So if there aren't good alternatives, so if this patent is blocking the main path that a competitor would need to follow from a technological perspective, and it's aligned with the business, and it's the kind of thing that could be protected with a patent, then we're going to raise the priority of that and say, okay, this is the kind of thing that would be a key thing to protect. There's a point I wanted to make there. It's not only the big products that are worth looking at for patent protection. One of my favorite places to mine for good inventions is when developers have had a really difficult time implementing something. If there's some part of the product that they really had a tough time figuring out how to actually make it work. And often developers, when they figure out how to get past that roadblock, they'll instantly forget it because they didn't like the thought that there was anything that impeded their progress. But from an IP perspective, that's a great place to go back and look and see if there's a technology that could be wrapped up in a patent that would be protected, because a competitor would have to follow the same technological path. And if you could get a patent over that solution that the developer came up with, it could be a really nice tool to block competition.
So, talking about blocking competition, what are the sort of realistic abilities and challenges of trying to enforce your patent, right? You've gotten it, let's say it's been awarded, and then you are fairly confident someone is infringing against you. How do you go about that? And what is the limitations? Let's say it's a big company that's infringing you.
Well, if it's a big company, in one sense, that's a great situation to be in, because big companies often have deeper pockets. And so it's much easier to get a law firm interested in participating in an IP enforcement action against a company that has deeper pockets. And often there are law firms that are willing to do it on a contingent basis or some type of hybrid contingent basis that will lower the costs. So I talked before about patents being gems. If it was just money and it was relative strength of money between a small startup and a large company, the small startup is never going to have enough money to budge the larger company just with money. But patents can be a force multiplier, because the infringing activity of the larger company can potentially be so dangerous to the company that they're looking at a David versus Goliath situation. That small patent that impacts lots of their products can actually be, the lever that moves the mountain. But
So they have much more at
exactly.
risk because they are a much larger company.
Now, on the flip side, if you're looking at competitors that are small and are fast followers, those fast followers are actually going to be more nimble at responding to the threat of a patent than a larger company. And so they may just swerve and switch their business model to avoid entering that part of the marketplace that you've closed off. We had that happen with one of our clients. We used a tool for a new type of patent application called a track one prioritized patent application that shortens the normal 3 to 4 year patent process. Well, in this case, it shortened it all the way down to 3.5 months. And so this very early startup got a very broad patent in 3.5 months. And one of their fast follower competitors that was actually VC funded heard about this and just dropped out. They just completely changed their business model, and actually the VC ended up getting hired as an executive at our client later that year.
So this must have been a pretty strong patent that they had high confidence it was going to stand up. It wasn't sort of ambiguous in whether
No, it was on some
go through.
early fundamental blockchain technologies that this company was innovating with, and it really had a deterrent effect. And some of the most effective offensive patents are ones that are never enforced. It's just ones that a company is public about having, and then sophisticated competitors look at what those patents are and make a judgment call not to compete in that space. So just the FUD, the fear, uncertainty, and doubt that a strong patent portfolio can creates a natural moat that some competitors will just avoid. That said, some competitors will walk into the moats, and then it's making a judgment call of what is it worth, similarly from that threefold perspective, from the legal perspective, from the business perspective, and from the technological perspective. Do we want to go after that person that is encroaching on the patent scope?
Got it. Now, patents, of course, are not forever. So once you get the patent issued, how much time do you have, and when does that clock start?
So the clock starts when you file. It used to be the clock started when it issued, but that allowed some people to create these submarine patents that stayed pending for decades and then only issued decades after they had been filed. The clock now starts when you first file a patent application, and then you have 20 years. Now, if the patent office introduces too much delay into the process, they will give you some additional time at the end to make up for losing some of your protection during that 20 years. But provisional patent applications don't count against your 20 years. So you can file a provisional patent application, have that last for up to a year before it expires, and then you file your non-provisional. And so you can effectively get patent protection that lasts until 21 years later. And so early on with startups, I'll want to talk with them about what kind of technology they have. Is the kind of technology that looks like it's a bell curve technology from a value perspective, that it's start low, increase to a certain point, and then within the 20-year period, the curve is going to go back down. In which case, you want to get that patent issued as quickly as possible in that 20-year period to capture as much of the bell as possible. But there are other types of technologies that just continually increase in value over the life of the patent. And those, and you particularly see this in the pharmaceutical space, where the value just keeps on going as the market grows with the pharmaceutical. It's actually desirable to give up your first year of protection by filing a provisional, maximizing the length of that provisional, and then filing a non-provisional at the end of that, so that your patent expires 21 years later, but you capture the tallest part of the curve for an extra year at the end.
So we've talked a lot about patents here. Is there anything about copyright that early stage companies need to be taking seriously and paying attention to?
Absolutely. Copyright is one of your least expensive, most effective enforcement tools that you have if you're creating content that other people might copy. So the most important part of the phrase or the term copyright is copy. Because while a patent will protect you against somebody else who creates something independently, copyright only protects you against somebody who has copied your content. So if somebody independently creates the same thing somewhere else, then copyright won't protect you. So there are actually software development companies that are in the business of what they call clean room development, where they will tell another company to create a software product that solves this particular problem, but they won't give them any of the code or any access to the software that they want to copy. And
But they can tell them in detail
they
how
will
to
tell
do
them
it.
how to do it, just share none of the content. So give them a very detailed requirement spec, but none of the content. But for people that are making copies, the most important thing to remember about copyright is in the US, it needs to be registered if you're going to enforce it at all. And registration is very cheap. Startups have a lot of confusion about how to get copyrights because some people hear, well, you get a copyright as soon as you create it. True, but in the US, you can't enforce that copyright unless it's been registered with the Copyright Office. And so even though you have the copyright, you can't sue anybody on it really unless it's registered. And registration then brings in some additional benefits, the main one of which is called statutory damages. What statutory damages are is instead of having to prove how much damage was caused by somebody copying your content, you can go to the court and the court will just set a damage level per infringement. So if you say, okay, for my image that I created, I've registered the copyright, somebody made 1 million copies, you go to court, judge says, okay, $1 per infringement. Every time that image loads in a web page, loads into a computer's memory, is downloaded somewhere, that's an act of infringement. And that $1 tick starts accumulating. And so it can be a very effective tool and very inexpensive from a litigation perspective because it's a very simple litigation to go after and enforce somebody. This is why there are some content repository companies that part of their business model is tracking down people that have taken their images or taken their videos or taken their content and are repurposing it without permission. They have sort of an assembly line lawyer process where they send out notices saying, hey, you have made these copies. They'll offer a settlement early on in the process. But if you don't settle, there are actually quite high damages that can accumulate if you have to go to court.
So a lot of people think about copyrights in terms of creative things. So you've got videos and photos, images, paintings, written content. What about source code?
Source code is creative. Talk to any developer, or if you give 10 developers the same requirement spec, they are going to create a different written document every single time.
So do you encourage startups to register copyright on the source code that they develop?
I do. If they think that there might be any chance that somebody outside the organization would get access to it. So if they are not particularly secure in their cybersecurity, or if they're using contractors, particularly contractors in other countries, or they have employees that they don't view as long-term stable employees. If people are going to be migrating in and out of the company, code gets put put into all kinds of memory devices, not the least thumb drives. People work on it from home. They work on it on different laptops. Code just tends to migrate. So if you want to keep people from reusing that copy somewhere other than your company, then strongly encourage copyright protection. And copyright protection for source code, we price it a little bit higher since we use something that we call code obfuscation, because the Copyright Office doesn't require that you provide the complete source code when you register it. You can obfuscate some of the code. And so we hide it so no one could look at the copyright registration and get the actual source code. But you could take the actual source code and compare it to the copyright registration and say, yes, these parts match up enough that it looks like there was a copy here. It's only with us, it's only $600 to have attorneys do the copyright registration with a $45 government fee. It's kind of a no-brainer if you think that people might get access to the source code. But you can also protect the object code. So the actual compiled end product can also be registered for copyright protection as well. And so for people that you're afraid might be decompiling your object code and then creating derivative software from what they've decompiled, that's still a copy. And that would still be copyright infringement. So if that's a threat that people are worried about, it's a very inexpensive IP protection to get. And for companies that are being acquired, it's a nice part of the due diligence to show that you've had a diligent record of protecting your major releases via copyright registration.
Now, I think we could do a very deep rabbit hole talking about copyrights and APIs, but I think I'm going to put that off for another conversation. Let's wrap up on a question of patent or copyright versus trade secret, and how do you advise people to think through that process?
So one of my favorite examples on trade secrets that I use in many of the courses or talks is the example of RC4. So RC4 was an encryption algorithm that was developed. It was a stream cipher algorithm, and it was kept as a trade secret by the company because they thought it was so valuable that they didn't want it to expire when patent protection would have caused it to expire. They thought it would continue being of value for more than 20 years. One day, in a discussion group, somebody anonymously posted a snippet of source code and said, here's the source code for RC4. Now, one of the challenges with trade secrets is the way you enforce a trade secret is you find the person that stole the trade secret, or the term is you misappropriated the trade secret. They took it without permission. And you sue that person. Because this disclosure was anonymous, there was no one to sue. And because you couldn't sue, you couldn't prove that it was a trade secret violation. Maybe somebody with permission disclosed it. Maybe somebody wanted to destroy the secret. You don't know. Now that source code is now in use still to this day under the moniker ARC4, alleged RC4. It's perfectly interoperable with the trade secreted, arguably, RC4 license code that is still out there. But trade secrets are only a trade secret if they remain secret. And there's an argument as to whether this trade secret still exists or not. Now, if RC4 had been copyrighted as well, that code had been copyrighted, there would be another tool that could have been used to keep the copies of that software from replicating.
It wouldn't have stopped someone from reproducing the algorithm in a new piece of software, though.
But once they've been exposed to that software, their mind has been polluted.
Right. It would have to be a clean room scenario like you described before.
Right, but it's really difficult to think about how you could come up with a clean room scenario from such a simple piece of code.
That's true. RC4 is really, really simple.
And so it would be difficult. So any requirement spec that detailed the algorithm would have to draw on the details of that source code enough that it would be considered a derivative work and it would still be a copy. So it'd be tough to get a clean room development environment out of that. Usually a clean room development environment would be algorithm independent. So it's solve this problem with some algorithm you develop. And if somebody else was as smart as Ron Rivest and could, come up with their own stream cipher that was compatible with RC4 on the spot, well, then maybe they deserve to get the protection for that.
It sounds like then, your advice typically biases towards getting the overt protection rather than trying to keep it as a secret?
So I have this discussion with a lot of my clients, and we'll often take a belt and suspenders approach. Treat it as a trade secret, but there are ways of filing patent applications where the patent application stays confidential. So if you just want patent protection in the US, you can file it, ask that it not be published by the patent office, and keep it pending for as long as the trade secret is still in force. But as soon as you lose control of the trade secret, then take steps to accelerate the patent process. So that if you lose the trade secret, you fall back onto the patent. And using code obfuscated copyright registrations as well, where that protects it against inadvertent permissive releases of trade secrets. So if somebody in the business side of a company says, hey, let's jump on the open source bandwagon and accidentally open sources code that has trade secret information. Okay, now the company has destroyed their trade secret. They may not have intended to do so.
Right, they forgot to password protect their Amazon bucket,
right,
or what have you.
Well, then that gets into a question of, was there an expectation of privacy there or not? And that's another it depends answer. But if they intentionally release something and they intended for it to be public, then that destroys the trade secret. But if they wanted to control how that was used, because even free software and copyleft uses rigorous use of copyright law to control keeping that open source material open to people.
Well, I think this has been great. You shared a ton of really useful information. I hope that the viewers will have a much better understanding of kind of what the options are, what the processes are, how to think through this. I'd encourage anyone to please leave comments down below if you've got follow-up questions. I'm sure I can twist Adam's arm to coming back on here again and maybe do some deep dive into some narrower issues that are coming up. But till then, Adam, it's been a real pleasure talking to you. Thanks so much for coming on.
Thanks for inviting me, Lance.
Thanks for watching this episode of Feel the Boot. I hope you found it useful and interesting, and if so, please like, subscribe, comment, and share. It makes a huge difference to us and tells the algorithm that this is the kind of information that'll be useful to other founders. And I want to emphasize, if there was anything in this interview that you'd like to see more detail on, or if you have follow-up questions for Adam, please let us know down in the comments and I'll get him back on and we can talk some more about those topics. Till next time, ciao.